Tēnā koutou katoa. Welcome to this webinar on safeguarding children and young people's privacy in New Zealand. My name is Pearce and I'm a policy advisor here at OPC. With me online today, we have a really wonderful panel and they're made up of experts in education, the law and privacy. And they'll be sharing their views on key issues in the children's privacy space. Welcome to our panelists. We have Kathleen Kaveney from the Post-Primary Teachers Association, Darryn Aitchison from YouthLaw Aotearoa, Dr. Annette Mills from the University of Canterbury and the Privacy Foundation, and Rebecca Hawkins from the Privacy Foundation. So in this webinar, each of our panelists will be talking about our organisation's recent submissions on OPC's Children and Young People's Privacy Project, which I'll talk a little bit more about later. And we'll end the webinar with a Q&A. Feel free to submit your questions throughout the webinar, and please use the Q&A box in Zoom, and we'll choose a selection depending on how many questions we have and how much time we have at the end. So I'll start us off by talking about the journey for the Children and Young People's Privacy Project. It started a couple of years ago. OPC had been hearing through various channels that this is a growing issue in the privacy space and warrants some exploration. For example, in our biennial survey in 2022, we heard that parents are very concerned about how they can protect their children's privacy. When we look internationally, we can see that other countries have turned their attention to children's privacy. The United Kingdom has enacted its age-appropriate design code. In the United States, there's the Federal Children's Online Privacy Protection Act, and we can also see various states taking action to protect children's privacy and safety. Some examples include state-level bans on certain apps and sites that they think present a risk to children. And then also in Australia, we have seen some specific recommendations in our recent review of that act. So they're just a couple of examples in a really fast-moving space, and they're certainly not the only countries that are working to protect children's privacy in their jurisdictions. As a result of these developments, OPC included a work stream on children's privacy in its strategic plan, meaning that improving protections for children is an organisational priority for OPC. And that brings us to the Children and Young People's Privacy Project. Children's privacy is a huge topic. And there are 1.2 million people in New Zealand under the age of 20, and they all have diverse needs and interests that require protection. Children and young people need to be given the space to allow them to form their identity, to figure out who they are and what is important to them. And privacy provides the space for exploration and must be protected carefully. But how do we do that? To get an idea of the key issues and a sense of where to start, the office ran some consultation late last year. We asked government agencies, professionals who work with children, NGOs who advocate for children's rights, and other experts for their views on the most important issues affecting children's privacy in Aotearoa today. By getting a wide range of views, we have a better understanding of the biggest concerns, what needs to be prioritised, and whether there are any quick wins that we can have to improve children's privacy protections. Last month, we released our report outlining the key themes that we heard during this consultation. And you can find the full report on our website alongside a short summary of all of the themes. But I'll quickly summarise it today so we all know what we're talking about. In total, we received 113 responses, including the submissions from our panelists. Across the responses, 3 key themes emerged. The first theme is about the need for more guidance. Professionals who work with children were clear that they wanted to know what the rules are in their line of work, and the situations they deal with are complex and always changing. Therefore, the rules need to be easy to follow and apply. We also heard that parents and children need resources to help them understand how to protect their privacy. The second theme described the regulatory changes that submitters wanted to see in order to protect children's privacy. The suggestions were varied and ranged from small to significant regulatory changes. Among the suggestions was a requirement for agencies to consider the best interests of the child in order to align with the UN Convention on the Rights of the Child, creating a right to be forgotten, increasing transparency requirements for agencies so that children know what is happening to their information, restrictions on how agencies can use children's information, and creating a code of practice to regulate how children's information is handled. The third theme, which sits on top of the first two themes, is social media. The concerns raised from parents using social media, children on social media, to social media companies collecting children's information. Submitters wanted to know how they can navigate the risks of social media in their work, and they wanted to see some more regulation here. So now that I've summarised the themes, I'll just take a really quick moment to say thank you to all of those who took the time to share their thoughts with us. These will be really helpful, and we'll continue to use these submissions as we continue on our work on children's privacy. We also saw some similar themes in our most recent biennial survey at OPC, which was released earlier this week. 88% of respondents said that they think that EdTech providers should only collect the minimum amount of information that's necessary, and 82% said they would like to see more regulation and legislation to protect children's privacy. Of course, among the submissions that we received in the Children and Young People's Privacy Project were our panellists. So they each drew on their expertise to explain the key issues that they see in relation to children's privacy practices and made suggestions on how we can improve privacy outcomes for children. First up, we have Kathleen Kaveney from the Post-Primary Teachers Association, who will be able to share her knowledge about the education sector and the views of secondary school teachers. All right, Kathleen, I'll pass over to you.
Morena koutou. Tēnā tātou katoa. He uri a hau ki ngā iwi o te tau ihu o te waka a Maui, I mahi ana a hau ki te PPTA te Wehengarua. Kia ora, ko Kathleen a hau. I am an advisory officer for the PPTA, which is the Secondary Teachers Union, and we represent 22,000 secondary teachers across the country. In our submission, we support the Privacy Commission's work in this area, believing that there does need to be a greater focus on guidance and education in particular to ensure that the privacy rules are well understood. We consistently have feedback, and my own personal experience is that the understanding of privacy rules by young people and their parents and teachers is possibly limited to when it impacted them, and there's not probably as wide an understanding as there needs to be. So a big part of our submission was the role of education and PLD, possibly that the Privacy Commission could run. We know that they've got a lot of resources online, but we find in education that quite often that is what the ministry, for example, the teaching council, they would say they do this work and they put it on their website and that's the end of it. And we know that teachers are very busy and are not scrolling websites for the most up-to-date information in PLD in that way. So the Privacy Commission could think about workshops, for example. We know they've got lots of good case studies, but these, how to populate it in schools would be the big thing. But I suppose a major part of our submission was that in the secondary school space in particular, it's a really complex area. Many of you will know that social media has a big impact on most of our lives, but young people have been born into it rather than people of my generation, I would say. And that means they don't necessarily use it in the way that we do or feel about it the way that we do. And some of the issues that secondary schools are routinely dealing with in terms of privacy, particularly around relationships with young people. We know that the sending of nude photos is, I think there's some stats that are quite horrifying about the number of young men and women who send nude photos, online postings that they make, that they're not realising that impact of their words. We have the media, a great media interest in fights in schools, which young people video and then they are put online without a real understanding of how that impacts other people. And so in those examples, and I have experience that I know other teachers have, live videoing in class of the teacher or other students, and really our experience is that young people have very little understanding of what privacy of other people means. We also know that it's a really complex area because we are finding that there are lots of sensitive issues that a young person, particularly if they're over 16, may not want to be sharing with their parents around, for example, gender identity, sexual health, and it puts schools in a really complex situation of having to manage parental expectations as well as student privacy. Other issues in secondary schools, as in other parts of our society, increasing use of video in school and video surveillance, which starts out to keep schools safe, but there's kind of no addressing of the privacy of who is surveilled in that situation. We also know that young people are interested in this, but possibly only when it really impacts them. And part of our submission was around the Privacy Commission perhaps thinking about an advisory group with young people, panels and workshops with the young people. We do know that in terms of senior leaders in a school, that is student leaders, this could be a really good area of work for them. I'm just checking my own notes. I suppose the biggest thing for us is that we do not believe, or we would not have strong confidence that young people really understand the privacy law for themselves. Don't necessarily think that a young person would have the confidence to complain about privacy breaches, for example, without representation from their parents. And and again, teachers are often operating in an area where they're wanting to do their best, but not necessarily completely au fait with what privacy rules might be. And another area in terms of privacy in schools that's an increasing issue, we believe, is the amount of online learning that is going on. That not necessarily the issue, but that the data of young people is used by multinational companies. We don't necessarily know what data they're using. They're not necessarily getting permission. I could say that in terms of a school, the checks and balances on the software that is used in a school is a bit hazy. Many schools are Google schools, some schools are Microsoft schools, and that doesn't necessarily mean that the school has a good understanding of the privacy of any of the data that can be going out of their school to either of those companies, for example. We would see that there checks and balances and that there needs to be greater input from the ministry in terms of education there, and advice to schools on what is the best to do. So I think, Ella, that I've covered all of the parts that we were talking about. I noticed just at the bottom of my page there, the other thing is young people's images that go out online. parents putting, or we all putting our own social media images out there, but young people really do not think through the consequences of what they do when they are 8, 12, 16, and the impact, the long-term impact that they can have. So in particular for us, advice and guidance, and targeted advice and guidance would be good. There are different levels that the Privacy Commission could think about targeting their work at. So if they're dealing with young people, any information needs to be in language that a young person would understand. There are forums or ways of getting information to young people that might meet their needs better, possibly via social media. But definitely there's that layer of parents themselves knowing and understanding how privacy impacts their lives and what advice and guidance is there, as well as teachers. And in a secondary situation, guidance, anybody working in the guidance area, be they guidance counsellors, nurses, social workers, they have quite a lot of complex situations, and advice and guidance in that area, as well as for principals, would be great.
Excellent. Thank you so much, Kathleen, for sharing your views there. Next, we have Darryn Aitchison from YouthLaw Aotearoa to talk about YouthLaw's submission and to provide some insight into the types of issues that he sees in his work. Darryn.
Kia ora koutou, ko Darryn Aitchison aho. I'm the General Manager of YouthLaw Aotearoa. I've been working in the community law space for about 15 years now, 16 years, something like that. I must confess I'm quite new to the youth sector. Most of my work as a lawyer in community law has been with adults, but I've done a lot of work that's sort of focused on systemic issues within the justice system, kind of identifying, what those issues are and thinking about how they could be resolved. Just want to, thank the Office of the Privacy Commissioner for leading out this really important kaupapa, and for the opportunity to, just share, I guess, out the perspective of YouthLaw Aotearoa. Excuse me. One of the things that I guess is really great about being new to a sector is that I've spent the last 8 months or so meeting some really amazing people and just trying to get a sense of what's sort of going on, I guess, in the sector. And I must mihi to the people that I've met in the last few weeks who have really informed my understanding a lot more since we made our submission around what are sort of the issues that are happening in the privacy space. It's very, very clear to me that this is a really passionate sector, that people work with young people because they want to make a real difference to those people's lives. And they want to work in a way that is in the best interests of young people that they support. One of the key messages I've been hearing is that the workforce is quite frustrated. They frequently find themselves in situations where they're not sure what the right thing to do is, or they've got a very clear idea of what the right thing to do is, but some manager or policy or piece of guidance suggests they don't do it. So it's quite I guess what I'm sort of seeing is that with privacy, if you think of privacy across a spectrum, at one end, there's a whole bunch of issues which it's really clear about what to do, and that will be to keep young people's information private. At the other end, there's a bunch of people working with high-risk individuals, and in some situations, disclosure of personal information is going to be an important thing for those people to have clarity around. What I'm really getting a sense of is that there's quite a large grey area that sits in the middle of that spectrum, where people have a lot of uncertainty about what to do and how to navigate the privacy space. So I guess what I'm interested in exploring from YouthLaw's point of view is how do we narrow that channel of grey stuff so that it's much clearer. More privacy issues sit in the clear space than in the grey space. And the issues that we identified as a team when we were putting our submission together, we've continued to sort of unpack with various people. But I guess a quick summary of what we're seeing is as follows. So one of the drivers of uncertainty and kind of large grey spaces is incomplete and splintered information. So you might have agencies who have basic privacy policies, but the information around what to actually do in a situation might sit in the health and safety policy and some in the privacy policy. And so this kind of splintered matrix of information within agencies is a real problem. It leaves teachers and other professionals working with young people in a space of uncertainty. There's also issues with competing rules. So one of the key problems is that, in a workforce, say for a school, for example, you're going to have a whole bunch of different laws, a whole bunch of regulations, enactments, you'll have codes of conduct. They might all be pushing and pulling people in different directions. In a school, you're going to have counsellors, nurses, teachers. They're all got different ethical rules. They're all framed slightly differently. That is also a driver of uncertainty. It causes confusion, essentially. Which set of rules do I follow? The principal might lean towards the teacher's council ethics, whereas the counsellor will, of course, lean towards their ethics. So that's a problem. I think the other thing that we sort of feel is that lack of specialist knowledge. Some of these issues, there's always going to be grey issues. There's always going to be complexity, and people working with young people need to have access to specialist knowledge, whether that's a phone line at the Office of the Privacy Commission or someone at their peak body, whoever it is. There's a whole bunch of ways you could do it, I suppose, but having access to that specialist information and knowledge when you do get complex issues is also, or the lack of it is driving uncertainty as well. A couple of other areas. So there's a lack of consistency within a given sector. So you've got a bunch of schools in Auckland all doing things slightly differently. Theoretically, they're applying the same law, but they're all doing things slightly differently. So that creates kind of white noise and uncertainty across the sector. And then you've got, which I've sort of alluded to, but the lack of consistency and alignment between sectors, so that you've got the health professionals over here doing one thing and the teachers over here doing something else. And that's confusing and noisy. And that creates risk. We've had cases at YouthLaw, for example, where young people have made disclosures to a health professional who's contracted into a school. They escalate the issue through their policies by notifying the school, but the information was provided on the condition that it was held confidential. Of course, the school or the parents weren't told, but of course the school's got a policy to tell the parents. So there's these gaps in inconsistency across different providers that cause this noise, I guess. One of the things that I'm interested in is the fact that, from a legal point of view, there's usually a right answer for most privacy problems. Unfortunately, in some situations, they're so complex you don't know what the answer is until a judge tells you. But there is usually a right answer, even with the system that we've got. In most cases, it's possible to navigate your way to the right answer. And I guess what I'm suggesting is that if we think about the problems I've identified, what can we do right now to problem solve within this space and actually start to make that grey area more narrow? And I think there are some things that we should be doing. The Office of the Privacy Commissioner and other legal experts, we should be charging them with the responsibility to make clearer statements about what the law actually is. Professional organisations and industry should be looking at their policies again in light of those clearer statements. There should also, I think, be interagency work done. So where you've got, trying to get convergence with all of the Auckland schools, for example. You could get all the privacy officers from all of the schools together, using those clearer statements of what the law is and starting to look at the processes that sit across the whole sector. That would be something that could be done, should be done, I think. And then there's also intersector kind of work that should and could be done. So protocols and MOUs between agencies and between sectors to kind of streamline and make sure there's more convergence, and essentially, trying to take noise out of the system and make the grey area a bit more narrow. I'm plagiarising in saying these things because the people that I've spoken to in the last few weeks who are working in this space, they can see this stuff, and there are people working on this and trying to do this. One of them said that they feel that there's a responsibility on agencies to actually do it now, not wait for the law to change, but get on with this work now. And to quote them, they said, "Our collective inaction is creating risk for young people and causing harm." So while we allow this noise to sit in the system, we are causing risk and harm to young people. The flip side of that is that we're also causing risk and harm to the professionals who work with young people. They're experiencing uncertainty, stress. They're going to make mistakes in their work. They're going to be sanctioned for those mistakes. So, we're in a situation where we actually do have levers within the current legal framework to make things better, and we should be trying to pull those as soon as we can. Probably rambling on through my time, so I'm just going to make a couple of quick comments about some other levers we've got. A code of practice, really sensible thing to look at. Really should be, the Office of the Privacy Commissioner, I think, should try and work on that and see if a code of practice could be developed and whether it's appropriate. I think the subsequent speakers to me had a greater knowledge around this stuff than I do, so I'm not going to dive into what that might look like, but certainly, or whether it's even the best thing to do, but certainly, a code of practice can do a number of things. It can explain when a particular privacy principle should apply, shouldn't apply. It can make rules a little bit more stringent or a little bit more loose. So it gives us ways to play with the grey stuff and really make sure that there's some greater convergence across the whole sector around these issues. I'm a big fan of best interests of the child and young person type principles. This is a really something I'm familiar with as a lawyer, having worked in family law areas. All that principle really says is, when you're faced with a complex privacy issue, do what's in the best interests of the child. It's reasonably simple to state. It's not necessarily simple to do, but it's a really rich and dynamic kind of paradigm, because it allows you to navigate the grey by getting all of the information you need to make a sensible decision. It's a sort of a process that it would imply and encourage people to do, but it's also it provides the best interest of the child is very much specific to the child, so it allows quite a lot of richness around different cultural perspectives and things like that. So what disclosure might look like in a Pākehā family might be different than disclosure in a Māori family. Having the wider whānau approach. So I think that's something that we should be looking at at least as a theory for a code. In terms of changing the law, I do think that there is reasons to change the law. So there's two reasons really. One is by having a right to privacy explicitly stated for children and young people in legislation, that's the highest law in the land. You're sending a clear signal that this is really important. So simply having that stated in the legislation would be a really great thing. It just focuses attention and decision makers in the right direction. But there's also new problems that are occurring and perhaps new rights that we'd like to create through legislation. The right to be forgotten, I think, is really important. I grew up in a time where all of my misdeeds are basically sitting within the failing memories of myself and my besties at the time. My children are growing up in a time where they don't enjoy that same privilege as I had. So I think the right to be forgotten is probably something we should look at. And then, there are other ones as well. One that I thought of in a bit of jest is that perhaps we could include a right to recover the profits that parents make by monetizing their children on social media. So in your 20s, you can sue your parents to recover the income that they made off you, but that might not be something we need to really do. So I think that's sort of covered it for me. Happy to, yeah, looking forward to a Q&A at the end. Kia ora.
Excellent. Thank you so much, Darryn. And finally, we have Dr. Annette Mills and Rebecca Hawkins to talk to us about the Privacy Foundation submission on the Children and Young People's Privacy Project. Take it away.
Hey, kia ora koutou. Oops. Okay, kia ora koutou. Okay, that's not. I have to use yours.
Seems like we might be having some technical difficulty.
Okay. No, that's fine. Hopefully you can hear me.
Yeah.
Okay. So kia ora koutou. Welcome everyone. Thank you very much to the OPC for giving us this opportunity to speak. My name is Annette Mills. I am part of the Privacy Foundation of New Zealand. I'm also a professor in information systems at the University of Canterbury and the current convener of the Children's Working Group. Rebecca?
Kia ora koutou, ko Rebecca Toku. I'm really pleased to be here today talking about the Foundation submission under the Commissioner's project. We really welcome the report. I'll just speak briefly to a little overview of the summary of the submission that we made, and then Annette will talk to some of sort of the key issues or concerns that we have and that we've talked about within our working group. So under our submission, we commented that children and young people are a vulnerable group whose right to privacy needs special protection. Particularly, we were thinking about this in relation to commercial interests. Our submission spoke to the view that there needs to be a rights-based approach to children's privacy and thinking about the need to balance the right to privacy with innovation. One area of focus for us has been particularly on EdTech, education technology, which we underscored really as an area where privacy guidance is needed. Because as one of the fellow speakers, Kathleen, had picked up, we appreciate that schools won't have always the negotiating power to have privacy protecting clauses and contracts, and that it can be difficult to assess privacy risks of data collection and use given capacity and resources. So under our submission, we presented a range of options to better support children's privacy, including the strengthening of law and a clear focus on transparency and notice. We've also looked a little bit, as Ella talked about, what happens overseas and thinking about what Aotearoa might be able to do and take from that.
Okay.
Thank
Thank
you.
you.
Hopefully this works this time. I'm not quite sure. So as I said, we're part of the Privacy Foundation group. We made a submission on the children's privacy, as Rebecca has outlined. We have a number of areas of interest, particularly when it comes to children's privacy. We discuss a number of related issues, including things like, for example, I'll pick up on one that was mentioned earlier, parents sharing children's personal information on social media. The potential profiling and commercialization of children's data, whether this is through educational technology or any other technology that they interact with. The opportunities and potential risks of AI for children, and including as well emerging issues associated with children using, for example, home devices like Alexa, smart technologies, and even toys. In terms of the submission that we made, we particularly focused on the challenges around educational technology. So recent studies, and this is coming out of the US, sees EdTech as a surveillance technology. We don't necessarily take that very strong view, but we do recognize that there are both pros and cons. As a surveillance technology, there's a US study that suggests that it harms students by teaching students the wrong lessons about issues like authenticity and taking risks. It undermines their privacy and it erodes trust in teachers, school staff, administrators. It might even inhibit students seeking self-help and perhaps even increase fear among students as well. Some of the pros of the technology, certainly educational technology, we see that as helping children to improve their learning. It helps children to learn in new and innovative ways, can make learning fun, get those activities that they enjoy engaging with, make it more accessible. For example, giving access to learning resources that they otherwise would not have. Think of, for example, a virtual reality visit to Rome to see the Colosseum and being able to walk through it. But then we can also ask questions. Is that same experience exposing children to behavioral profiling? It helps to individualize learning, improve communication and teamwork. We can use technology also to detect and respond to developmental issues. So there are a number of pros to using technologies to support learning, to support play, etc. for children. But what about some of the issues? So certainly a large issue that comes up in the space of educational technology has to do with the dominance, I would think, of this space by some of the large multinational firms. We ask questions such as, for example, what do they do with the data? How is the data shared? What is it used for? Is it used to profile children? Some of the potential issues that I could see arising from that. For example, in educational technology, we want to make sure that we keep children's attention. But even those attention strategies could actually raise questions, such as what does it mean when we use technology to direct or perhaps control how children behave? The technology itself could lead to the discovery of vulnerabilities, but at the same time, it could also open up avenues for exploiting those vulnerabilities. Technologies could also reinforce narrow sets of emotions and behaviors. In other words, children learn that this is what is acceptable, and so therefore that is how they behave. But that affects identity. It affects their development. It affects creativity. Children are no longer allowed or may find themselves constrained when it comes to making choices as to how they want to go about their own lives. Hyper-personalization. Here we're restricting information flow. So if someone chooses, for example, one particular thing that they like, blue or whatever it is, then you find that everything else after that follows that trend. It may be that that was just simply a random choice. But what personalization can do is that it can end up restricting the autonomy and freedom of children and hence their own development. We see it also as something that violates human rights. In fact, there are provisions where we should be able to have freedom of expression, have access to information. As we said earlier, it can impact their personal development, self-discovery, creativity. And hyper-personalization creates what we refer to as echo chambers that then perpetuate that personalization or that bias. And then, of course, it can promote conformity to someone's opinions. We ask the question, whose opinions, whose cultures are driving that? So those are some of the issues that we see. And arising from those issues, we then made a number of recommendations.
So yes, we had quite a range of options that we presented under our submission. I'll speak to a few examples here, and Annette may also have some specifics that she wants to touch upon. But just to give sort of a high-level overview, we definitely, from the perspective of the foundation, advocated strongly for strengthening of the law. We definitely consider that it's really appropriate to adopt that rights-based approach when provisioning children's privacy. We recommended consideration of adopting an age-appropriate design code like the UK has, and Ella referred to. So that looks at app developers and those providing online services for children and providing some rules or regulation in that space. And we also recommended that there are some specific constraints around the use of children's information, particularly in regards to biometrics. We definitely supported the OPC's finding that guidance should be produced, and we recommended that for schools, helping them with assessments around the scope of third-party information collection and completing privacy impact assessments. With that option of looking at an age-appropriate design code, there's the inclusion of standard privacy by design principles. And one aspect that I really like within that is one that I think can resonate with us all and really make sense, something that we should all expect, is that privacy information is concise, it's prominent, and it's in clear language that's suited to the age of tamariki or each child, and that it's delivered in those little bite-sized chunks. So we definitely think that it's really important to focus on transparency and notice when we're looking at an option around protection.
Okay, thank you, Rebecca. So some other recommendations that we also made, transparency. So we see statements like, for example, wanting digital platforms to be more transparent around how they collect and use the information of children and young people as critical. So transparency should be a provision in any sort of code, and we are advocating a children's code. We also see that there needs to be real adherence to principle number 3, which regards openness as to why information is being collected and what will be done with it. We also advocate for privacy by default. Children should not have to go through all sorts of mechanisms to try to set their privacy settings. So that should be by default. With that, we also advocate for data minimization. This aligns with OPC's recent findings regarding the collection and use of information, only collecting and using what it is that is absolutely necessary, and only retaining it for the period for which it is necessary. We also advocated for restrictions on data sharing. This also applies to big tech as well. We took a strong position on geolocation tracking, calling for the prohibition of that, as well as prohibiting targeted advertising. We also see profiling and automated decision-making around children, and particularly in the space of education. We feel that that sort of use needs to be limited or prohibited, as may be the case. And we feel really strongly, going back to an earlier point, that children have a right to the freedom to develop, to be creative, without being nudged, without being profiled, without being guided, controlled, directed. Of course, some amount of guidance is important, but there's a fine line between what is good for development and what becomes almost like surveillance. This also brings up another point around constraining the use of biometric information for profiling children, whether that's behavioral. Banning the use of nudge techniques, especially those that would lead to or encourage children to provide personal information that is unnecessary, that would weaken or that would encourage them to weaken or turn off their privacy protections, or anything that would extend their use. And we see a lot of that happening in social media as well. A right to be forgotten or a right to erasure. This should include erasure of information that is posted by others. And here we can look at something like sharenting, so where parents are posting information or anyone else is posting information related to a child. And then finally, of course, things like consent. We'd like to see clarity around who gives consent, particularly in schools. I think this is a challenging area because a lot of educational technology is collecting data. And at present, schools may ask parents to just simply give a sort of wide sweeping consent to all the various technologies without little or no opportunity to be informed or to opt out. At the same time, we recognize that schools are challenged. They don't have the resources to necessarily understand and look at and choose other technologies. And so therefore, when we talk about consent, we have to see it in light of what is practical and what schools are able to do. And so therefore, we really feel that it is important that they be provided the resources that they need to make good choices and to also respond to the various privacy issues that are raised around the use of educational technology and particularly the commercialization of children's data. So that then takes us to what we see as the next steps and what can be done. And in general, this can cover things like educational technology, AI toys, social media, etc. So first of all, public awareness campaigns, picking up on all these key issues that are related to children's privacy and ensuring that parents, whānau, schools, whoever the stakeholders are informed and can make good choices, and that they have the resources to do so. Especially for educational technology, we feel it's important that greater support is provided to schools so that they're cognizant of the privacy issues and the issues around commercialization of data. And secondly, that specific resources are provided to schools so that they can assess ed tech that they're using to promote the safety, privacy, and of course, address any authorization and consent issues. So that's in summary what we had submitted. Thank you very much.
Thank you very much, Annette and Rebecca. All right, well, thank you to all of our panelists. I might move us into the Q&A portion. I'm just noting the time. We have just about 12 minutes left. So I did have some back pocket questions, but I think I might go and start answering some of the ones we've received. Also, just a reminder, please feel free to submit any and all questions. If we don't get to it and you still have like a really burning need to have your question answered, then you can always email us afterwards. I'll give out our email at the end of the webinar. So one that jumped out at me was one that asked, what are your thoughts on the pervasiveness of Google products in learning, such as Chromebooks and Google Learning, amongst others? And then there was a link to an article, which I haven't read yet. But yeah, so what are your thoughts on how just pervasive these technologies are in schools? I'll throw open to everyone, but perhaps I'll start with Kathleen, just because of your education background.
Thanks. Yes, they are very pervasive in the secondary area. One of the issues is that along with the technology, sometimes the various companies provide PLD servicing, and I have to say a lot of it comes down to money for schools, best bang for buck, who's going to provide the computers as well as any help that is needed. Computers in schools, though, a lot of it, for an actual teacher, there are contracts that the ministry makes, so many of them it's through a teller scheme. But in terms of what schools are asking, many ask them to get the Chromebooks because the Chromebooks have less applications, so it's more controllable for a school to not be able to let kids go on Facebook, for example, is one of the ones that I'm thinking of, which is a problem for many schools. But my answer there is that they're very pervasive, and I would have to say the advice around checks and balances would not be strong in schools or for schools.
Great. Does anybody else have any thoughts about the question?
We're just trying to minimize the echoes here. Sorry, I had a quick look at the article, and it's around what Denmark is doing to address this. And I think it's a very laudable position, and actually making organizations be responsible for what they are doing with children's data. I don't think individual schools can do this. This is something that is going to have to come from a much higher level, whether it's the Minister of Education or someone else who actually ensures and put in place not only guidelines. Guidelines are one thing, but very high fences or guardrails, whatever you want to call it, that is going to ensure that that technology is used for the betterment of students, not for commercialization. And I think, again, I don't know what the line is, but I think there is a fine line between surveillance, profiling, and things that would direct children in a way that we don't feel is useful for their development. So I'd love to see a strong position on that.
All right. Unless anybody else had any thoughts, I might move on to another question. So the question is, thoughts on the use of social media for marketing in early childhood education centres? So I think we can probably expand it to any, but the question is specifically around ECEs. But yeah, does anybody have any thoughts about social media being used to market these centres? Perhaps I'll start with Rebecca. Do you have any thoughts?
Sorry, just checking that that's all good in terms of the echo.
Yes.
Perfect. So the questions around marketing just generally in the education space?
Yeah, so using social media. So I would assume that would cover things like using
Yeah,
children's
so this
faces.
is one of the risks that or potential privacy harms that we've talked about within our children's working privacy group from a foundation perspective, that yeah, we would see it's wholly inappropriate to be marketing to children. You know, there's lots of when you're looking at, say, the international context and the law in the states, for the federal law from the Californian side of things, that's got explicit provisions around the fact that you're not meant to be marketing to children. So yeah, I would say not something that should be occurring.
What about using children's faces in advertising, for example, like taking pictures in the classroom and then putting it on social media to say, look how great our classroom and our learning environment is. And while there's a really good intention there, what are your thoughts on that then being posted on social media or used more generally in advertising, where the children are the product, I guess? Maybe Kathleen, do you have any thoughts on that? And then maybe I'll throw to Darryn as well, because I've been rudely excluding you.
Well, I do think that's an issue in schools. We do have situations I'm specifically talking about secondary, but I'm sure it's primary as well, where a school will ask, is it parents give permission to use their child's image in social media. But I heard somebody make the point earlier that it's kind of a generalised permission slip. And so most schools do that and then go ahead and use the young people's images. Having said that, I'm not sure the young people are at a point where they say, yes, I'm happy to have my picture on, Westlake Boys website. So that is an issue. And going back to the ECE one as well, young people can't give permission who are under 5. So the use of a child's image there is a problem.
Absolutely. Darryn, do you have any thoughts on this question? And we can make it a bit more broad if we'd like, but just about using children in advertising.
Yeah, I guess it doesn't seem consistent with the best interests of the child principle. It may well be lawful. I'm not going to make a comment on that because need a little bit more detail, but certainly hard to see how it aligns with the best interest of the child. Hard to see whether a best interest of the child analysis has been done. Unlikely to have been done. Probably there'll be a tick box exercise around making sure you've got consent. As Kathleen said, there might have been a disclaimer that you signed 3 years ago when your child enrolled. But that's not the same as in the moment thinking about this young person and their interests. Am I going to pop them on social media? I mean, who knows what's happened in that person's life? It might be that family's broken up, you've got parenting orders in place now, you've got aunties looking to get contact with this child who, there's whole lots of things that could be happening in the background. And a best interest of the child approach would require the organisation to consider those things, or at least ask the questions before they decided to do it.
There's definitely, just to follow up there, sort of as well as the authorisation point, we've thought about it from a foundation perspective as well, around very much perceptions and feelings can change over time. And, whilst it might be fine to take a photo in 2024, you might then feel different about it a couple of years down the line. And I think the OPC actually has published a wee blog post or one of those FAQs that you've got around thinking about how you're taking photos in the classroom or or for kind of promotional purposes, say like if it's for a sports club in that as well. You're going to have to also think about the kind of the retention that sits with that image. You know, how long are you actually going to be using it for? Is it just for a specific campaign, or are you thinking that this will forever be the image?
Yeah, and I think there's also a difference between like a really posed photo and a candid shot. And so I think that's something that should also be taken into account potentially, because if the child doesn't know that their picture is being taken, they may have some feelings about that. We have some really meaty questions in the Q&A, and so unfortunately we have run out of time, I think. So we've only got 2 more minutes. So I might just have like a summary question to throw to everyone. If you had to name one thing that would make the biggest difference to improving children's privacy protections in New Zealand, what would it be? So I feel like that'll be a nice way to sum us up. Perhaps I'll start with Darryn.
Thanks very much. I think, I think having a strong signal in legislation that children and young people have specific vulnerabilities and need greater protection would be the single most important thing that we could do. But I also think, just from my presentation, there's a lot we can do with the existing law, and we should do that now rather than wait. So 2 things.
Kathleen.
Well, from our perspective, it is about knowledge and understanding that young people, teachers, parents know and understand what privacy means in their settings. And so we would again want to see more efforts made to increase understandings in that area through PLD. And I did read a chat earlier, definitely face-to-face rather than just putting things online. And trying to understand young people's experience and use that to strengthen the laws.
Excellent. And Rebecca.
Okay, certainly one of the things that I would put forward is putting the protection of children at the forefront and letting that be the benchmark that then determines other actions. Once we do that, then it will help us to know what do we do about children's images on social media, how do we handle ed tech, etc. So I think we have to start with that foundation. What is important?
Very much agreed.
Excellent. All right, thank you so much to our panelists for taking the time to share all of their really valuable thoughts. And thank you to everyone who has tuned into the webinar. If you do have any questions about the Children and Young People's Privacy Project, we do have some information on our website, but you can also email children@privacy.org.nz. All right, that wraps us up now. Ngā mihi nui, thank you everyone.
Ka kite anō.
Thank you.
Thank you.